The date for former President Trump's classified documents trial is staying put. Well, for now, at least. U.S. District Judge Aileen Cannon ruling that the May 20th, 2024 trial date would remain on the calendar, but she would push back several of the key pretrial deadlines in order to give Trump's legal team more time to review the evidence in the case. Judge Cannon also left the door open for delaying the trial, signaling that a potential move could be ordered at a March 1st scheduling conference. Meanwhile, in the D.C. election subversion case, Judge Tanya Chutkan isn't budging on her early March trial date. Judge Chutkan ruling this week that she would require Trump to disclose whether or not he'll be using an advice of counsel defense, a legal defense strategy essentially blaming his alleged conduct on his legal team. Joining me now, MSNBC legal analyst and former federal prosecutor and the host of the Justice Matters podcast, Glenn Kirshner. Glenn, it's been a busy week. Let's start with Judge Aileen Cannon, one of my favorite topics, down here in Florida in Fort Pierce. She's saying, I'm going to keep the May 2024 trial date for now, but says she'll revisit it on March 1st. Listen, you and I have seen this language. We've experienced it as former prosecutors. Are you going to take a bet on whether or not this trial is going to get pushed out beyond the November 2024 trial date now?
Yeah, I'm not exactly a betting man, not a high roller. $1 is my betting limit. But, Katie, I'm going to place the full buck on this trial date will not stand. And the reason I say that is, listen, I think there are valid reasons to continue to question Judge Cannon's experience, certainly in this arena, her temperament, as can be seen by her legal rulings in which she gratuitously criticizes Jack Smith and his team over and over again. And she still has that partiality problem, I would suggest. And when you look at the 9-page ruling that she just issued, if you go to the last 2 pages, she actually continues or pushes farther down the road a full dozen deadlines. Now, some of that is understandable. The discovery that's been given to the defense by the prosecutors has been voluminous, so it's not unusual that some of these deadlines would have to be pushed down the road. But what you just said in your lead-in, Katie, is most important. She set a status conference hearing date, what we often call a control date, for March 1st. What does that mean? On March 1st, the parties will gather in a courtroom in Florida. And if the D.C. prosecution of Donald Trump, Judge Chutkan's, that Judge Chutkan is presiding over, is in the chute to begin jury selection 3 days later, March 4th, then I am almost certain the May trial date in the Florida case will get continued. It will get pushed down the road. Will it get pushed beyond the November 2024 election? Well, let me just say, depending on the result of the trial in Washington, D.C., that may matter less in the event Donald Trump is convicted in his D.C. case.
And before we move on to that D.C. case, I'll add the following scheduling footnote for our viewers. Judge Mershon, in the Manhattan DA criminal case, because, you know, we always kind of forget to mention that one sometimes, right? That was the first that came around. They're going to have a February 15th, 2024 scheduling conference to talk about whether or not the trial moves forward in March of 2024 as well. So that's another one that's going to be on up at bat. Let's talk about that order from Judge Chutkan about Trump formally declaring if he's going to use an advice of counsel defense in D.C. Judge Chutkan's not moving the trial date, still stuck for March of 2024, but by January 15th, Trump has to advise the government whether or not he intends on using that defense, Glenn, and he also has to turn over all communications that he says evidences this kind of reliance defense, and he also has to turn over any evidence that he doesn't even intend to use at trial, but would substantiate that defense. What are your thoughts about all of this attorney-client communications being turned over to the government?
Katie, I love this issue because Donald Trump and his lawyers have been talking, at least, you know, in the public square, if not in court, about maybe relying on an advice of counsel defense. And let me just say, advice of counsel defense can be a legitimate, even a compelling defense. If I hire a tax attorney to help me do my taxes and he or she tells me I can take a certain deduction because it's lawful, I do that. And the IRS says, Glenn, yeah, it wasn't lawful. What do I have? I have an advice of counsel defense. Here's the problem, Katie. One of Donald Trump's lead attorneys, Rudy Giuliani, was investigated by Jack Smith to see if he was intoxicated during the time he was giving legal advice to Donald Trump on and around January 6th. Guess what? There is no advice of drunk counsel defense. But even worse, Donald Trump, in an interview, I believe, with Kristen Welker, said, you know what? I didn't really rely on my lawyers. I relied on my own instincts. Guess what? There is no reliance on your own instincts defense. I hope he goes with that one because his instincts are often corrupt, if not criminal. But here is the, I think, most dramatic problem for Trump. His counsel, his attorneys, like Rudy Giuliani and Sidney Powell and Kenneth Chesebro and John Eastman, are his charged co-conspirators, criminal associates, co-defendants in the Georgia RICO case. And the one thing I can tell our viewers is there's no such thing as an advice of co-conspirator defense. Donald Trump has nowhere to turn on this one.
And Glenn, let's stay on this path for the time we have left together. What about the admissibility of things like Kenneth Chesebro, Sidney Powell, Jenna Ellis admitting their guilty pleas, right, in Fulton County, and things like Rudy Giuliani in a civil lawsuit that was brought by Ruby Freeman and Shay Moss saying, yeah, I didn't, I'm conceding liability on this. I knew that what I was saying is not true about fraud being perpetrated. I mean, is any of that going to be admissible in a trial like that in front of Judge Chutkan?
Absolutely. All of these are real danger zones to Donald Trump. And most recently, we've seen just how sweeping the evidence that Jack Smith seeks to introduce against Donald Trump will be. It looks like his approach is no piece of incriminating evidence will be left behind. It will all be presented to that D.C. jury. And the fact that so many of Donald Trump's attorneys have already admitted guilt, that evidence will absolutely make a showing inside that D.C. courtroom.
Glenn Kirshner, as always, you break it down in a way that we all can understand, and it's important because justice matters.
Justice
Thanks for
matters.
being here, friend. Always. Thanks for being here.